for us to be.
Morning, everyone. Thank you for joining us today. My name is Richard Ruff. I'm a supervisor with the City of Chicago's Office of Labor Standards, which is the division out of the Business Affairs and Consumer Protection Department. And today's webinar will be going over the rules that are supporting the Chicago's Minimum Wage Ordinance. So what are promulgated rules? Pursuant to chapters 225 and 6105 of the Municipal Code of Chicago, the Commissioner of BACP has the authority to adopt rules which provide clarity and additional guidance to the Chicago Minimum Wage Ordinance. The Office of Labor Standards, OLS, has published updated rules on both the BACP and OLS websites in December of 2023. A public comment period, which accepted comments through mail, email, and an electronic survey, ran through February 16th of 2024. Our department, Office of Labor Standards, individually reviewed every public comment and incorporated many of them into the final versions of these rules. The rules pertaining to the Chicago Minimum Wage Ordinance were finalized on May 1, 2024, and then updated again on June 24th, 2024 to take effect starting July 1st, 2024. How do I access these published rules? So the rules are accessed through the City of Chicago Rules portal at that web address listed there. And from there, you will filter by department and select Business Affairs and Consumer Protection. The screenshot on the side of the slide shows the area where you would select the department and then scroll down, clicking on Business Affairs and Consumer Protection. That would then give you the list of all of the department's rules that are published for their ordinances. And this is the front page of the Chicago Minimum Wage Rules supporting Article 2 of Title 6. Again, this is the page where they were published June 24th, 2024, going into effect July 1st, 2024, that were signed and approved by our then Commissioner Kenneth Meyer. Article 1, the general rules. Section 1, definitions. These are the definitions that are used throughout these rules that define what is going to be talked about during the rules. So as used in these rules, the following definitions apply. Calendar week means any consecutive 7-day, 24-hour period. It may begin on any day of the week and any hour of the day. So it does not have to be a traditional standard calendar week. It can be Tuesday through Monday, Wednesday through Tuesday. The chapter means chapter 105 of the Municipal Code of Chicago as currently in force and hereafter amended, which is the Minimum Wage Ordinance. The department is just our department, Business Affairs and Consumer Protection. Gratuities means voluntary money contributions to an employee from a guest, patron, or customer in connection with services rendered. Occupation means an industry, trade, business, or class of work in which employees are gainfully employed. Tip allowance means the difference between the tipped wage and the non-tipped wage. So right now, currently, we have a tip allowance for tipped workers, which is going to be phased out by July 1st, 2028. The current tip allowance is 32% of the posted standard minimum wage. And then every year on July 1st, it is going to decrease by 8% until 2028, when it would be equal to the standard minimum wage. And then a tipped employee means any employee engaged in an occupation in which employees customarily and regularly receive more than $30 a month in a gratuity. Section 2, general provisions and information. Rule 1.01, immigration status. Immigration status does not affect an individual's status as a covered employee. Chicago is a welcoming city, and we will not ask the status of immigration of anyone that, files a complaint with our department. Rule 1.02, day laborers. Day laborers are considered employees. Therefore, day laborers who perform at least 2 hours of work for an employer while physically present within the geographic boundaries of the city are covered employees. Rule 1.03, notice and posting. Employers shall post the notice prepared by the department through the employer's usual methods of communication for such notices, whether by paper, posting, or electronic dissemination through the employer's internal communication channels. When posting a paper notice, the notice shall be printed on and scaled to fill a sheet of paper that measures 11 inches by 17 inches. So it's not your standard 8.5 by 11 piece of paper. These notices are also available in many different languages on our website, should you need them. The notice an employer is required to provide with the first paycheck may be provided prior to the commencement of a covered employee's employment or as part of an onboarding process. The notice shall be printed on and scaled to fit a sheet of paper that measures no less than 8.5 inches by 11 inches. However, where covered employees are enrolled in direct deposit and do not receive a paycheck, but have the option to view their pay stubs electronically, employers may provide the notice to the covered employees through the employer's usual methods of electronic communication, including but not limited to email, dissemination through internal communication channels, and as part of an employee handbook or part of their paid leave policy. The notice employers provide with the first paycheck shall be provided yearly with the first paycheck on or following July 1st, whether by paper or electronic means stated above. This is just to notify the employees of the current minimum wage as it usually is adjusted every July 1st based on the consumer price index. And then all notices shall be posted in English. In addition, an employer shall request and post notices in other language if a significant portion of its workers are not literate in English. And for purposes of this rule, a significant portion means 5% or more of the covered employees working at that job site. And as I stated before, there are 12 different languages posted on our website that have these notices, which the employers are able to access. Rule 1.05, contents of records of employers. Employers must maintain at a minimum the following records for a period of not less than 5 years and shall make such records available for inspection upon request by the department. 1, the name of each covered employee. 2, their mailing address, telephone number, and email addresses of each covered employee. 3, the occupations and job titles of covered employees and whether they are tipped, non-tipped, or perform duties of both tipped and non-tipped positions. Hire date of each covered employee. 5, rates of pay for each covered employee. 6, hours worked each day and each work week by covered employees. 7, the type of payment, hourly rate, salary, commission, etc. And then both straight and overtime pay and total wages paid to each covered employee in each pay period. 8, additions and deductions from each covered employee's wages for each pay period and an explanation of additions and deductions. 9, dates of payment of each pay period covered by each wage payment to each covered employee. B, if the commissioner reasonably determines that an employer is operating in violation of the chapter or any other applicable provision of the Municipal Code of Chicago, the commissioner may issue an order in the form of a subpoena directing the employer to provide the information, including but not limited to the name of the business, the address of the business, the details of the information being sought pursuant to the chapter, and any information necessary to demonstrate compliance with the chapter within the control or possession of the employer. The employer shall, within 30 days of the date on which such order is issued, either provide the information or file a legal objection to such order in writing with the commissioner. If the employer files a legal objection, the commissioner shall provide a hearing on the objection within 10 business days. Commissioner's determination shall be final and may be appealed in the manner provided by law, and nothing in this rule shall be considered a limitation or restriction on the commissioner's powers and duties under chapters 2-25 of the Municipal Code of Chicago. Rule 1.06, additional record requirements for tipped employees. Employers must maintain at a minimum the following records for tipped employees for a period of not less than 5 years, and shall make such records available for inspection upon request by the department. A, the report received from the covered employees setting forth gratuities received each workday. The amount by which the wage of each such covered employee has been deemed to be increased by gratuities as determined by the employer. Hours worked each workday in any occupation in which the covered employee does not receive gratuities, and total daily or weekly straight time payment made by the employer for such hours. D, hours worked each workday in occupations in which the covered employee received gratuities, and total daily or weekly straight time earnings for such hours. Article 2, these are the minimum wage rules. Rule 2.01 for the Chicago minimum wage. A, as of July 1, 2024, the city's minimum wage for each hour of work performed for an employer by a covered employee is as follows. $16.20 per hour for employers who have 4 or more employees or hire a domestic worker. So the domestic worker is covered whether there is 1 or 2 or 3 or under 4. For employees that are employers that have less than 4, they would default to the federal minimum wage, which is $7.25, as both the city and the state require that employers employed more than 4 or more to be subject to their minimum wage. 2, there's $15 per hour for subsidized temporary youth employment programs and for subsidized transitional employment programs, as well as covered employees who are under 18 years of age, and those subject to the Section 6 of the minimum wage law. B, updates to the city minimum wage will be posted to the website of the Department of Business Affairs and Consumer Protection. Rule 2.02, tipped employees. As of July 1, the allowance for gratuities of what an employer may pay its tipped employees allows the minimum wage for each hour work performed for an employer by a tipped employee is as follows. B, $11.02 per hour for employers who have 4 or more employees. C, $10.20 per hour for the subsidized temporary youth employment programs, subsidized transitional employment programs, and for covered employees who are under the age of 18 years. And those also subject to Section 6 of the Illinois minimum wage law. B, if a tipped employee does not succeed in making up the difference between the allowance rate and the Chicago minimum wage, the employer must pay difference to the tipped employee. So for example, if a server at a restaurant works for 2 hours but does not receive at least $10.36 in tips which is equal to the amount of the tip credit, which is $5.18 per hour. Then the employer would need to pay the remaining difference. E, updates to the city's minimum wage will be posted on the website of the Department of Business Affairs and Consumer Protection. Rule 2.03 goes over the overtime. A covered employee is entitled to at least 1.5 times the city minimum wage for each hour in excess of 40 hours worked in any particular calendar week. B, tipped employees are entitled to an overtime wage of at least 1.5 times the city's minimum wage minus no more than the current maximum tip allowance. And then C, if a covered employee's wages plus tips do not equal the number of hours worked times the applicable minimum wage, the employer must make up the difference as soon as is practicable, no later than the next regularly scheduled pay period. And then just going back to the minimum wage for the standard minimum wage, it is currently $24.30, which is just 1.5 times $16.20. But for the tipped minimum wage, it is not figured as 1.5 times the tipped rate of $11.02. It is taking the $24.30 and subtracting the tip allowance credit of $5.18, which makes it $19.12. Again, any updates to the city's minimum wage will be posted to the website on the department. Article 3 is our complaint procedure and city investigation. Rule 3.01, filing a complaint. An employee who believes that the employee's employer violated a requirement of Article 2 of Title 6 may file a complaint with the department. A complaint may be submitted through any one of the following methods. 1, you can call 311 directly. 2, you can use the CHI 311 mobile application. 3, you can download and mail a complaint form to the Office of Labor Standards, Department of Business Affairs, Consumer Protection at 2350 West Ogden Avenue. We're actually now on the 2nd floor, and Chicago, Illinois 60608. And the complaint form is found online at our the address listed there or through our website. And you can download and email the complaint to our office at bacplaborstandards@cityofchicago.org. And the complaint shall state the alleged violations and any underlying factual basis. And then all complaints filed with the department shall be filed within 3 years after the alleged violation. However, if evidence exists that the applicable employer concealed such violation or in any way misled covered employees to the employer's or covered employees' rights or responsibilities, such investigation shall commence within 3 years of the date on which the covered employee or department discovered or reasonably should have discovered the alleged violation. The complainant shall provide support for their claim to the department and any supplemental documents and information upon request. Employees are not required to provide, and the city will not request information regarding the immigration status of any person filing a complaint. F, the department may resolve the complaint by conference, voluntary mediation, conciliation, or persuasion. The department will consider multiple factors in deciding the monetary fines assessed to an employer for violations of this chapter. The factors include, but not limited to, whether the department finds that the employer made good faith efforts to cure, correct, or mitigate violations after such receiving notice of the complaint, or whether the department finds the violations were of a technical nature and did not cause material harm to covered employees. And then Rule 3.02 is the severability clause. These rules are declared to be separate and severable if any clause, sentence, paragraph, subdivision, section, subsection, or portion of these rules or the application thereof to any employer, employee, or circumstance is held to be invalid, it shall not affect the validity of the remainder of these rules or the validity of the application of the rules to other persons or circumstances. And this is our office's contact information with phone number and email. There's also the email to our department's outreach division and our mailing address. Any questions?
You do have some in the chat box.
Employees' records should be kept for 5 years. Is that correct? Correct. What is the minimum wage regularly without being a tipped employee if you have more than 4? It is currently $16.20. For employers with less than 4 employees, due to both the city and the state of Illinois having a clause that their minimum wage applies to 4 or more employees, it would default to the federal minimum wage, which is $7.25. However, I don't know if that's necessarily a good thing to provide employees as far as to retain employees.
We still have time. Please put your questions in the chat box. We still have time for more questions.
When will we know what the minimum wage will be on July 1st, 2025? The CPI is usually released in, I believe, May, so it should be updated not too long after that. Company is required to adjust wages accordingly at the time of increase by the state. When the state increases theirs, we're usually typically higher than them, so you're subject to our ordinance, so it wouldn't be required until ours goes up. What if there are ways they can make tips if they are paid $7.25? I'm not quite sure what you're asking. If you could email our department at the BACP labor standards, we need a little bit more clarification on that to get you a better answer. Good morning. Does this affect independent contractors? If so, in what fashion? I have several independent contractors on my team. So independent contractors are, if they're true independent contractors, they're not subject to the minimum wage law is only subject to employees. Do the tips have to add up to 1620 if you only have 4? Yes, if you have 4 or more, and you take the tip credit, it has to add up to $16.20 an hour. If 3 or less, it would have to, it's just $7.25. Does this increase apply to the suburbs as well? No. Our ordinance applies only to employees that do their work within the geographical boundaries of the city of Chicago.
Richard, you want to give them until 10:30? If not, we can end it.
Yeah, we can wait 2 more minutes. We can give them 2 more minutes.
Okay.
Can I talk a little bit about the tip credit? So the tip credit, it's currently 32% less than what the standard minimum wage is. So the employer, if it's a position that generally receives gratuities in the amount of at least $30 a month, you can take the tip credit, and then their minimum wage is only $11.02 an hour. However, the tips would need to make up the additional $5.18 an hour for the hours that they work. And then again, the tip credit is being phased out. So next year it's going to go down to only 24% of the minimum wage. And then the following year in 26 or 27, 16. And then to 20, and then to 8%. And then it will eventually reach in 2028 our standard minimum wage. More questions? Stella, I think we can end it.
All righty. If you are a part of the BACP Entrepreneur Certificate Program, you will receive credit for your attendance today. To learn more about our upcoming webinars, please visit chicago.gov/BACP webinars. Again, to learn more about our upcoming webinars, please visit chicago.gov/BACP webinars. Today's webinar was recorded and can be found on our YouTube channel at youtube.com/Chicago, youtube.com/Chicago BACP. Thank you and enjoy the rest of your morning.